Loaded talk, loaded grok. All right, right now, Hawaii is trying to argue in the Supreme Court for a law they tried to pass. Basically, the law is for those who can even have a gun in Hawaii. They go, okay, well, you can have it, but you can't get onto like public property, or I guess to other people's private property without their express consent. Now, that's different than saying, like in Florida right now, open carry has been a thing, and so you can put a thing on your door that says you can't have a gun in here. It's your private property. You're allowed to do that. You know, there's some sticky wickets if you get too into it constitutionally. But as far as private property rights, it's pretty much stands, you know. So that's kind of how it goes. You have the right until you're told not in here. You know, if with lack of further instruction, your Second Amendment rights stand, and you can bring it wherever you want. So Hawaii did it the other way. They go, unless someone says specifically, you're welcome to bring a gun in here, you can't. Okay? So that is what one might call an infringement on one's Second Amendment right. Second Amendment says the government can't make rules that infringe on one's right to carry. So you go, man, I wonder what arguments they have for it. Hawaii, very progressive state. You know, they're Democrat presidential, you know, elections often. They're about 60 to 70% Democrat vote consistently, you know. So it's very blue, very blue. And so you imagine they have some like top flight arguments, maybe something ACLU or something. Well, so they go, hey, what about the 1865 Louisiana law? And the Supreme Court goes, are you talking about the black codes, which restricted the right of former slaves and prohibited them from carrying guns on private property, such as plantations, without the owner's consent? So real quick, Hawaii, when the Supreme Court goes, now what precedent can you present for dictating how these people can carry guns on private property? They said, black laws. Charlie. And these laws, not just Louisiana, but in a lot of states, these laws were the birth of gun control. And why do you think, mainly in the South, but why do you think government officials, mainly in the South, didn't want these former slaves to have guns?
Because they were former slaves.
Yeah, they weren't happy about it. And also, let's just say you put on your best pair of bed sheets and a nice cone hat on, and you decide to visit your neighbors. Well, if one of them has a shotgun or 7, maybe you're going to pass their house. If they got no guns and you got a shotgun or 7, maybe you're going to burn across, and maybe you might see what they look like hanging from a tree. So the Klan, which existed, especially after Woodrow Wilson, but anyway, predating that, the Klan, one of the number one defenses against getting lynched by Klan members, which often members of the Klan involve the sheriff, the mayor, the governor. You know, you were not going to find legal redress in some of these regions as a black person. And so, you know, pew pew, Colt 45, law of the land. So if all of a sudden you go, you can't have guns, then you go, all right, you're allowed to, Second Amendment, fine. You can't take them off your property. Okay, so now what? You walk to work? You walk to anywhere? And now you're open to the Klan or just a redneck or whatever? These were not good laws. It'd be like a poll tax or the test one had to make to vote, except for life and death. All right. So the justices, likewise, look at all these ads. What is this? Post-millennial is the opposite of the Blaze. It's so ugly. So the justice question why such a law should be considered under the Bruin test, which was established in the wake of 2022 New York State Rifle and Pistol Association with Bruin, in which the court ruled that gun laws should be weighed to see whether they align with American history and tradition. Gorsuch asked, I struggle to see what relevance laws that are outliers, and in Bruin, we're not supposed to consider outliers, that they're put aside under our test. We're looking for the mainstream and significant tradition, and you rely very heavily on an 1865 black code and law in Louisiana. You say it's a dead ringer and a reason alone to affirm the judgment, and I really want to understand how this could be. So Neil Katyal, arguing for Hawaii, began talking about a California law, to which Gorsuch said, this wasn't the question. And why don't you answer the question posed? I want to understand how you think black codes should inform the court's decision making. It's quite an astonishing claim to me. Katyal, whatever, called the black codes undoubtedly a shameful part of our history. Well, that's good. But said that doesn't at all mean that this particular law isn't irrelevant to the Second Amendment analysis for two reasons. He said that when Louisiana was readmitted to the United States in 1868, the Reconstruction Congress examined Louisiana's laws, including the statute in question, and admitted it in 1868. They go, it stands, whatever. Gorsuch cut him off saying, you're not answering the question. The question is, it's an outlier, and you just called it a shameful outlier, and I agree with that. And Bruin was supposed to look at mainstream of our tradition and history, not outlying statutes that were unconstitutional the moment they were passed. And yes, when Louisiana was admitted to the Union, I understand a lot of people like to cite the black codes who promote gun restrictions, who would otherwise, they would be the garlic in front of a vampire in front of them. But here they like them, they embrace them, and I'm really interested in why. And so this dude claimed that the statute in the black codes was race neutral, and that Congress implicitly blessed it by allowing Louisiana back in the Union. So he goes, hey, look, this rule that was only for black people about their constitutional rights and about limiting them so that we could attack them. Race neutral, actually, when you think about it. When you think about it, it didn't have to do with stopping us from lynching them uppity blacks in the South. It was about saving people. Because guns.
Huh?
You got it. So Samuel Alito jumped in. He goes, wasn't the purpose of the laws and the post-resurrection South that disarm black people precisely to prevent them from doing what the Second Amendment is designed to protect, which is to defend yourself against attacks? They didn't want that. They wanted to disarm the black population in order to help the Klan terrorize them and other law enforcement officers in that period in the region. They wanted to put them at the mercy of racist law enforcement officers. So it's not the height of irony to cite a law that was enacted for exactly the purpose of preventing someone from exercising their Second Amendment right, to cite this as an example of what the Second Amendment protects. He continued. This guy's like, like we said this thing's unconstitutional already, and you're citing it as the reason things are constitutional. He agreed that parts of the black codes were motivated by and exactly that operation. But our point to you is this consent requirement did not operate that way. Indeed, if anything, it protected black churches and black-owned businesses and the like by insisting on this consent rule.
I would be laughing in the courtroom.
Yeah. He's saying that actually black churches and businesses were more protected by having to give permission to black people to bring guns in than if black people were just allowed to bring guns in, because safety.
Okay.
And like, let's go back to the times of the Klan. And you can't bring your gun anywhere, but the church and your business says, yes, you can. Well, it seems like the part that's protecting you is the part where you do bring your gun, not the part where someone goes, you can't have your gun. And if we catch you with your gun between here and here, you're in trouble. Let's see. Is there anything else funny in here? Let's see. Whatever. We'll just go through the whole thing here. Kavanaugh cited this, saying those were rooted in racial prejudice designed to prevent black jurors from having their votes counted. Yep, Kavanaugh, we just disagree with the idea that applies to this particular law from Louisiana. But regardless, our tradition goes way back before that. Yeah, no joke. The tradition of limiting black people's rights to own anything goes back before 1865. That's crazy. So Kavanaugh added, of those laws, a couple of them you cite seem to me you're approaching the whole analysis upside down from how the court's cases have approached it. The court's cases have started with the text, which declares an individual right. He said, the court elaborated that there are some exceptions, but those exceptions would be recognized, or to be recognized, must be historically rooted, deep tradition, broad tradition, widely recognized, commonly recognized, not isolated examples, particularly, but not ones from black codes. Now, Charlie, how many modern laws would you like to see based on black codes?
None.
Well, you're not going to get a mint julep, are you, boy? Why don't you come on down to Papa Frank's plantation? We'll rock on my rocking chair, chew some wheat, and have a nice mint julep and talk about the joys of the black codes.
Nice.
Yeah, I don't know. So that's it. Hawaii wants to enact black codes in Hawaii, but on guns, because black codes are okay. Good job, Hawaii.